Well, thank you very much, Alex. And on behalf of all the people at the Moritz College of Law at The Ohio State University who have been involved in this project, and there are many of us, it's really a collaborative effort. We do want to thank you, Alex, and Georgetown, and specifically the Supreme Court Institute, which has been very helpful in formulating the ideas that have led up to today. And of course, we're especially appreciative to John Fortier and Tom Mann and Norm Ornstein from the AI Brookings Election Reform Project for being willing to pursue this idea. There are many people and institutions that need to be thanked and deserve thanks. We have acknowledged them all in the program and also on the website. As a former law clerk myself, I want to thank in particular the three law clerks to our distinguished panel today, Jennifer and Carrie and Dan, because they put in a lot of work on behalf of the deliberative process here. The decision in this case will be posted on the websites of our organizations and will be disseminated in the newsletters of the sponsoring organizations, and the media departments of those organizations will also notify the press when a decision is ready. Now, a little bit of background about the purpose of today's event and the factual details of the case that is before the court today. The specific inspiration was a special three-judge panel that was created to a dispute in Minnesota back in 1962 for their governor's election. That election was Minnesota's version of Bush versus Gore. On election night, there was only a 60-vote difference out of over 2 million ballots cast between the two leading candidates, with the incumbent governor having that 60 vote. Immediately went to court over whether the local boards of election could correct the initial election night returns. That litigation went to the Minnesota Supreme Court, an elected court, and that court split 3-2 on a party line vote. And the good government folks in Minnesota thought that that was an unhappy and unsatisfactory situation. And as a result, the two gubernatorial candidates sat down and had a special panel to adjudicate the remainder of the dispute after the official certification of the election results. And that's what happened. There was a recount conducted under the auspices of that three-judge panel. What was special about the panel was it had one judge who was identifiable from one political party, another judge identifiable as belonging to the opposite political party, and the third judge was perceived as independent and neutral. And as a consequence, the panel was thought to be structurally fair, and when it handled the recount, it turned out that the result was the opposite of what election night showed, and the incumbent governor, in fact, left office, having even been re-inaugurated because it took a while. But both sides thought it was fair, and the people of Minnesota thought it was fair way to handle that kind of case. So today's proceedings is an effort to test, to experiment, whether or not this so-called Minnesota model would be useful or appropriate in the event that there is a dispute over presidential ballots. Now, of course, it's hard to imagine that presidential candidates, either back in 2000 or this year, would sit down and agree on this special kind of body. But it might be possible for future elections for Congress to legislate that something like the Minnesota model would be appropriate for presidential disputes. Because this year, even before Election Day, we've already been reminded of the difficulty that regular courts have in handling cases involving the rules over the casting and counting of presidential ballots. As many of you know, there was just an example of this this last week coming out of Ohio, and I think the paper reports are any indication, there's questions in the public mind about the extent to which regular courts are able to handle these cases in a way that avoids an appearance of partisanship on the part of the judicial rulings. Consequently, Congress might prefer like the Minnesota model for presidents. But even if it's unlikely that Congress it's possible that the private sector could create a neutral three-judge panel as an unofficial body in these situations. If the unofficial body ruled quickly enough in advance of a real presidential dispute that was before a conventional court, it could submit its own deliberations to the regular court in the form of an amicus brief. And since the unofficial body would be structured in this inherently neutral way, its decision would be structurally fair in that sense. And for that reason, it might have some persuasive impact on the regular court that had the case. Because the regular court would need to ask itself, why would its decision be any different from this structurally fair body? Because the media and the public would ask that question, especially if the membership of that body had figures of reputation of the highest intellect and integrity, as our panel today certainly does. Consequently, if there is indeed some concern that regular courts may, or at least appear to be tempted to be partisan in these cases, the submission of the unofficial body's deliberations may work to counteract that tendency. In any event, that's the hypothesis to be tested, and today's proceeding is just the first step in this sort of experiment. Now, of course, today, our three-judge panel is not deliberating about the merits of a real dispute. At least we hope not. We hope this remains hypothetical. But still, because our panel is treating this case as if it were real, its deliberations, today's argument, and the opinion that results from it will tell us something about whether or how this Minnesota model would work in a presidential situation. So that's the background and the purpose for this exercise. And before I give you a brief description of the Colorado fact pattern, I want to remind everybody today that our arguing counsel have graciously agreed to stay for about a half hour after the oral argument so that we can have a Q&A, question and answer session about how the argument went, the nature of this experience, and we will open it up to the audience for that purpose. Okay. For the next hour or so, today is no longer Monday, October 20. Instead, it is Monday, December 1st, and we are all now in the courtroom of the United States Supreme Court. The Electoral College is scheduled to meet in 2 weeks on Monday, December 15, and next Tuesday, a week from tomorrow, is the so-called safe harbor deadline, which you may remember from Bush versus Gore. That's the date that Congress has specified for all states to resolve any disputes involving votes cast for presidential electors. That is, the states must that date if they want their resolution on Congress. So what has happened since Tuesday, November 4th, the day that votes presidential electors? It turns out quite a lot, at least in Colorado, where our case comes from. Colorado ended up being the one key swing state this year, in the same way that Florida was in 2000 and Ohio in 2004. Whichever candidate gets Colorado's Electoral College votes will win the presidency. On election night, the networks could not declare a winner in Colorado. The return of all the regular ballots showed Senator McCain ahead by about 13,000 votes. But over 100,000 provisional ballots had been cast in the state, including about 70,000 provisional ballots from Denver, where Senator Obama had won over 2/3 of the regular ballots. So if the provisional ballots are counted, it is most likely that Senator Obama would win Colorado. But if the provisional ballots are not counted, then Senator McCain wins. There's a dispute over these provisional ballots from Denver. Most of them, about 60,000, were cast as a result of the extension of polling hours in Denver back on Election Day, November 4. The polls were extended by local Denver election officials because of a severe winter storm that hit the city during the afternoon, clogging rush hour traffic. As many of you who live in the D.C. area will remember a similar storm during the so-called Potomac primary earlier this year, when Maryland extended its polling hours because of similar bad traffic. Colorado Secretary of State, however, has objected to the extension of the polling hours in Denver. In his view, any extension of polling hours violates a state statute that says the polls shall close at 7 p.m. That statute says that voters standing in line at 7 p.m. may vote, but that, quote, any person arriving at 7 p.m. shall not be entitled to vote, close quote. Based on this statute, Colorado Secretary of State went to state court on Election Day to enjoin the extension ordered by the Denver election officials. But the state court permitted the extension as long as the ballots cast by individuals arriving after 7 p.m. were provisional ballots. And as I said, there are about 60,000 of these provisional ballots. After Election Day, the Secretary of State ordered the Denver election officials not to count those disputed ballots. So now the local Denver officials go back to state court seeking permission to count them. The dispute went to the Colorado Supreme Court, which split 4-3 in favor of counting them. The majority of the Colorado Supreme Court said that it would violate equal protection as guaranteed both by the federal Constitution and the Colorado Constitution if those ballots were not counted. In other words, it would violate equal protection not to count the ballots because the Denver voters needed extra time because of the storm. The majority cited turnout figures provided by the Denver election officials to support this contention. If only the regular ballots from Denver were counted, then Denver's turnout would be significantly lower than elsewhere in the state or lower than from Denver in past elections. Whereas if the disputed provisional ballots are counted, then Denver's turnout is more in line with elsewhere in Colorado and with the past. The state Supreme Court majority also cited a state statute which calls for the state's election laws to be construed, and I'm quoting again, construed liberally to protect voting rights. Now, the dissent on there was a dissenting opinion from the justices on the Colorado Supreme Court, and they argued the opposite position on the equal protection matter. The dissent said that strict enforcement of the 7 p.m. closing time treated all voters equally, and that giving Denver voters extra time denied equal voting rights to Colorado voters outside Denver, including those who lived in suburban neighborhoods who were also affected by the winter storm. The dissent rejected the majority's reliance on the so-called liberal construction provision of the state's election laws, saying that there was no room for liberal construction here, given this explicit statutory language, again, that says any person arriving after 7 p.m. shall not be entitled to vote. The United States Supreme Court has granted certiorari to consider the equal protection issues in this case, as well as to consider whether the state Supreme Court's decision violates Article 2 of the United States Constitution. Article 2, as many of you may remember, gives state legislatures the authority to determine the manner of appointing that state's presidential electors. Now, the only other background fact that you might want to know is that since the Supreme Court has granted certiorari, the Colorado governor, as well as the leadership of the majority party in each house of the Colorado legislature, all of whom happen to be Democrats, have held a joint press conference to say that they support the majority decision of the Colorado Supreme Court. They view it to be a correct interpretation of Colorado law, and they say that if the United States Supreme Court overturns that decision, then they will have to consider calling a special session of the state legislature, which is in recess at the moment. That special session would consider whether to invoke that Article 2 authority to appoint presidential electors. Meanwhile, the disputed provisional ballots, and thus the entire election, rests in limbo. There's been no certification of a victory yet. Instead, pursuant to the Colorado Supreme Court's order, the counting of all the other ballots has been complete and verified, and the provisional ballots has been processed up to the point that they are ready to be counted or discarded, depending upon what the U.S. Supreme Court does with respect to this case. Okay, that's the background. And the only other thing I think is valuable to remind everybody is that our three-judge panel is proceeding as if it has the full authority of the United States Supreme Court for the purposes of this case. They will exercise their own judicial judgment about what the law requires. In other words, they are the Supreme Court for this case. And with that, I want to turn it over briefly. Our judges will now proceed to get ready to take the bench, and we will call them in a moment. And meanwhile, John Fortier from the American Enterprise Institute and Brookings Institution's joint election reform project will come and speak a few words. Thank you, John.
Thank you, Ned. As Ned mentioned, my role is to fill time while the judges are putting on their robes. So I'm going to tell all of my jokes that I have about a hypothetical moot Supreme Court wrapped in an enigma, which will result in a decision next week. First, let me thank Georgetown and thank Moritz College of Law that sponsoring the event with the AI Brookings Election Reform Project, and thank our two co-directors of the project, Norm Ornstein and Tom Mann, sitting here in the audience. We, as a project, have been dedicated to trying to bring to Washington the research and the experience in election reform that has been going on since Florida 2000 to Washington policymakers, and to the general academic community. And today's exercise we see as very consistent along those lines. Certainly, a number of the facts of the case are not new developments since 2000. We have questions of extending polling hours, which existed before our reforms in the Help America Vote Act, and will continue to exist as we go forward. But we certainly do have some new aspects of election law that have been put in place here, that, like provisional ballots, as well as there is a reference in absentee ballots and the increase in alternative forms of voting, which is significant in this case. So we as a project support the idea of thinking about the new issues and problems that we are going to have potentially in our 2008 election, but also trying to find ways to resolve elections, a perennial problem. If you think of Mexico, if you think of countries around the world, many of them have specialized election courts which deal with issues that come up. We have other countries with more partisanly balanced or nonpartisan election tribunals which resolve elections. And here we have the opportunity to have an experiment to see what might come about if we were to tweak our system of resolving elections, at least at the judicial level. I note that this is we picked Colorado because it was an interesting new state on the political horizon, one that has been turning from red to purple. But we also have a couple of distinguished guests in the audience, I might note, who have a Colorado connection, and two of them sit on our Election Assistance Commission. Those are our Chairman, Rosemary Rodriguez, and our Commissioner, Donetta Davidson, who was the Secretary of State of Colorado in past elections. I think they're here for the general exercise that we are undergoing, but there are some particular aspects of this case that might interest them as well. So we look forward to hearing the results of this case. We have a couple of projects going on that Ned was too modest to mention that he is involved in, and also his colleague Steve Huffner. In terms of looking more generally at the recount process, at the contest process that is different from state to state. Also, Ned is involved in a project looking more historically at the history of disputed elections and how we have resolved them. So we hope that that sort of exercise plus this will give us an opportunity to have a real discussion about how we want. No matter what we do, no matter how we resolve questions of voting machines and provisional ballots and voter ID, things that we will argue about, no doubt, in the future, no matter how perfectly we get that, there will still be elections that are close and contested. And there's still a need for a series of procedures in order to resolve these elections, and a particular need for fairness and balance in the election contest, where the winners and losers are the plaintiffs and the defendants in suits, and that afterwards one of them has to govern. So we are. I'm looking for the signal from. Our judges should be here momentarily. Let me remind you exactly how this proceeds. We're going to take 1 hour. It's about 10:25. So in a couple of minutes, when the justices emerge, we will have a 1 hour oral argument. We will leave then time for half an hour for questions from you to the members of the panel while the justices deliberate, and we will look forward to your questions.
How hard could it be?
Looking for the judges coming over.
Yeah, we're.
We've been waiting for you to go get them.
I was looking for a signal, and Ned's going to. You're gonna do the OYA, right? We're gonna. While we have the time, I will mention another another event we are that our AEI Brookings Election Reform Project is hosting in Washington this Thursday. It looks at another set of circumstances that have.
Okay, we are good.
Well, why don't I finish that thought? Disrupted elections. This is the possibility of election being disrupted by either natural disaster or terrorist attack, and we have seen those sorts of things happen in New York on 9/11 and in hurricane situations. So Thursday at the American Enterprise Institute, we invite you also to join us for another exercise in elections not under ordinary circumstances.
Okay, we are now to begin. So please all rise. The Honorable, the Chief Justice and the Associate Justices of the United States Supreme Court. Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting. God save the United Honorable Court.
Morning. We will now hear argument in the case of McCain versus Obama. Mr. Nager, you may proceed.
Thank you, Mr. Chief Justice, and may it please the Court. Secretary of State Kaufman's decision to not to count ballots cast after the 7 p.m. deadline specified by Colorado Code Section 1-7101 was perfectly constitutional, because it held all voters equally to the same standard. And the Colorado Supreme Court's contrary decision commits 3 fundamental errors of federal law. First, nothing in the Equal Protection Clause requires a state to extend polling hours when the only obstacle alleged to timely voting is increased traffic resulting from a storm. Second, even if the state wants polling hours, it could not do so constitutionally under the Equal Protection Clause in the way that the Colorado Supreme Court has ordered here, because the Colorado Supreme Court's order here compels arbitrary and differential treatment of similarly situated voters in the state. And third, Article 2 of the Constitution vests the federally delegated power to specify the manner in which presidential electors will be selected to the legislature of states, not to the courts of states. And that prohibits the Colorado Supreme Court from revising or departing from the terms of the Colorado Election Code, and specifically here, its requirement that no person arriving at the polls after shall be entitled to vote.
Counsel, do you want us to bring down a rule in Article 2, the argument you just set out? That would be a first for us, right? So you're relying on some of the dissenters in Bush v. Gore?
No, Justice Wald. In fact, it would not be a first for the Court. The Court has looked at Article 2 issues before, including McPherson versus Blacker, and ruled on Article 2 challenges. That said, we have presented to the Court 2 different grounds, equal protection as well as Article 2, that the Colorado Supreme Court's decision violates, and either one of those is obviously a sufficient basis for complete reversal of the Colorado Supreme Court's decision and for a remand order directing dismissal of this lawsuit.
To win on both of your equal protection propositions in order to prevail on your equal protection argument?
Justice Phillips, I would say in response to that, the short answer to that is no. We only have to win on our argument that the Equal Protection Clause prohibits the order that the Colorado Supreme Court entered. However, it would be necessary in the course of explaining that decision that the court also make it clear that what the Equal Protection Clause prohibits, it can't also require. So in that respect, the court does also have to address the Equal Protection Clause requires arguments.
Why would extending the hours for polling pose an equal protection problem any more serious than had Mr. Scarpello simply dispatched a fleet of four-wheel drive vehicles to get voters to the polls in Denver County, but not in other counties, since he had no authority over other counties?
The difference there, Mr. Chief Justice, would be that the effect of the Colorado Supreme Court's order is to deprive people outside of Denver of the right to vote after 7 p.m., whereas Director Scarpello's extension of the polling after 7 p.m. allowed Denver voters to vote. If Director Scarpello had just done what you suggested, which had taken efforts to facilitate the arrival of voters to the polls before 7 p.m. to vote, there would not have been a differential treatment by the state excluding the right to vote and allowing others. What this court has repeatedly said is that the state has wide and broad and necessary power in regulating the conduct of elections. It needs to do so in an even-handed, non-discriminatory way. And
the weather doesn't apparently respond to that injunction, and it treated the voters of the state differentially, and so the director of elections, and each county director has to make his or her own decision, decides what is the nature of the weather. Is there a problem? Is there some problem at the polls that the director needs to respond to, and then makes a decision. Any other county director could have extended the time to the polls if that director thought the weather was an issue.
With all due respect, Mr. Chief Justice, no. The Colorado does not confer discretion on Mr. Scarpello in Denver or any other election official around the state to extend the polls. It says that anyone who polls after 7 p.m. is not entitled to vote.
Well, counsel, you're asking us to give a very absolutist interpretation, one that the Colorado Supreme Court itself did not accept, to this one provision which says that anybody who arrives after 7 o'clock at night should not have their vote counted. However, that's part of a provision in the revised statute called Hours of Voting, which says all polls shall be operated continuously from 7 a.m. until 7 p.m., etc. My question to you, partly hypothetical, but it will help me to understand your argument, is that if an emergency happens, if a tornado hits, if the electrical power goes out for a couple of hours during the election day between 7 a.m. and 7 p.m., so that the polls cannot be continuously operated, you would still say that there's no authority for the electoral district to lengthen the hours for voting beyond anybody that arrives by 7 p.m. I mean, you unlike the Colorado Supreme Court, think this cannot be violated under any circumstances. Is that right?
What I would say in response to your question is, Justice Wald, one is that the election scheme itself does not allow for any extension of the polling hours. However, if an event happened such that the jurisdiction was not fulfilling its requirement to keep the polls open continuously during that 12-hour period of time, I do believe that the Equal Protection Clause would require that jurisdiction to have its polls open for the same period of time that other jurisdictions around the state were required to have theirs open.
I can a question on that. So if I understand you, you are saying that this particular provision, since you've got two possibly inconsistent provisions, that the polls have to operate continuously and that nobody who arrives after 7 p.m. can have their vote counted. If there was something, is the line you're drawing, if it was something that the election that the state had control over?
That's correct.
If the voting machine stopped, if the electricity went out in the polling place, but anything outside, in other words, if the roads directly leading to the polling place had snow up to the sky and were impassable, too bad. That's an act of God, and therefore this provision waived to permit it. Is that right?
The short answer to that is yes. The reason for that, of course, is because the Equal Protection Clause doesn't apply to God. It doesn't apply to Mother Nature.
All right. And just finally then, what about the fact that, and I think it's referred to in the record at one point, the fact that the traffic congestion was so great that it provoked the electoral district people into extending the hours. Isn't that a responsibility of the state? In other words, the state didn't keep the roads clear enough so that people could get to the polls.
Well, with all due respect, I believe what the stipulated fact shows that there was speculation about whether or not there had been similar investments in roads care by other jurisdictions versus the state of Denver.
But there's no doubt that the roads were worse here than they were in parallel jurisdictions.
No, I don't think that in that particular instance that the...
Well, I'm reading from the record. Although some suburban roads suffered storm-related significantly worse during heavy traffic and minor comparison to what drivers were experiencing on Denver's roads.
And my answer to that is that government has to create the obstacle of the timely voting. If government doesn't create the timely obstacle that prevents the time for voting, government may, consistent with Article 2 and consistent with the Equal Protection Clause, try to accommodate where it thinks it appropriate as a legislative decision, but the Equal Protection Clause wouldn't require it. Where the Equal Protection Clause would require it is where the government had directly created an obstacle.
So if a tornado hit the polling booth, and I'll stop here, where if a tornado hit the polling station in the middle of the day, the government might but wouldn't have to extend the hours.
Well, actually, Colorado's electoral scheme has a provision to address that. It says if there is an emergency event which requires a change in polling places, then it should be done. That, of course, shows that the Colorado legislature thought about what exceptions it wanted. It didn't provide one for extending time. The important point for the Equal Protection Clause issue here, Justice Wald, is that in this particular instance, Director Scarpello did not do what he needed to do in order to get a proper extension. He didn't listen to the state official who he is directed by statute to take orders from, the Secretary of State. He didn't go to court.
That's state law. So is it your argument that if Scarpello had actually closed the polls in Denver from 3 to 5, let's say, in the afternoon, then the extension would have been okay because everybody had 12 hours?
That would be correct. He would have had to have made an adjustment if he had closed.
So that doesn't present an equal protection problem as far as you're concerned?
That is correct. There may be a state law problem with that.
This provision of state law, then, that provides that the polls don't open until an election judge that is authorized from each political party shows up at the polls, that is, in your view, unconstitutional then, because a poll where the judges were late then wouldn't be open for the full 12 hours?
I'm not sure I follow the reasoning as to why it would be.
Well, you seem to be stating a principle that unless all of the polls in all of the counties of the state of Colorado are open for precisely the same amount of time, there's an equal protection problem. There's some sort of differential treatment that we should care about.
With regard to the additional provision, all voters in Colorado were subject to that electoral code. that provided that you got 12 hours unless the election judges didn't show up on time. So in that particular instance, there's no equal protection clause problem with that, because everyone in Colorado is subject ex ante to the same rules by government. But the problem here, Denver voters were subject to a different set of rules than non-Denver voters. The snowstorm impacted cities beyond Denver, and none of those voters, whether they were affected by the storm or not, were given an extension of the deadline, whereas all Denver voters were. There were non-Denver voters who were on the roads in Denver, impacted by the exact same storm and the exact same traffic. They were denied the right to vote in their counties outside of Denver, whereas Director Scarpello extended the hours for Denver. And
so why would the remedy be then not to count those votes? I mean, you're going to tell 62,000 people or so who understood from a duly appointed election official that they had an extra 2 hours. Maybe they could have gotten there on time, but they thought that they had more time and that it would be more convenient, perhaps safer, to show up later. They acted in reliance upon that. Why would that be a just order on equal protection grounds?
Well, it would be an unjust order because it would violate the Equal Protection Clause by treating voters throughout the state differently. What this Court's decisions in Dunn versus Blunstein, in Bush versus Gore, in O'Brien versus Skinner say is that the state, when it comes to the actual right to vote, may not deny the vote to one where it grants it to a similarly situated other voter. And
you're not similarly situated,
right,
though. I'll yield here in a moment. You're not similarly situated if you've been told by your election official you have an extra 2 hours and you take advantage of that. 62,000 people you are suggesting should have their votes rejected now, not counted, in order that others who weren't subject to the same extension and didn't have anything to rely on and didn't have the same weather, because those others didn't have the additional 2 hours.
Well, Director Scarpello has not claimed in this case that he misled the citizens of Denver. Not surprising, he's not going to make that statement himself. And the answer is he was told by the Secretary of State that he did not have authority to extend those polling hours. And the other election directors around the state didn't extend polling hours. And what this court is reviewing is the Colorado Supreme Court's decision that says that the lawful basis for extending the polling hours was the exigency in Denver, and yet the exigency extended beyond the Denver lines to voters in other jurisdictions, and those other jurisdictions were denied the right to vote.
But if the county voting directors in those adjacent counties had also disregarded the Secretary of State's advice and opened the polls themselves, your equal protection claim would disappear. Isn't that correct?
That is correct. If all jurisdictions, either in the state of Colorado or impacted by the snowstorms, had extended the voting hours so that all voters in Denver similarly situated were granted the same amount of time, we wouldn't be presenting our argument that the Colorado Supreme Court's decision violates the Equal Protection Clause. We would, of course, be presenting our argument that the decision violates Article 2.
Why doesn't your claim then rest with people in a suburban county who were not allowed to vote, and the remedy is some type of very quick election for them, rather than denying people who presumably relied in good faith on a government directive and taking their vote away?
We're here, of course, as petitioner because we lost below, but we were in the trial court. And the question in this case is, what remedy has the plaintiff sought, and is that a constitutional remedy? And the remedy that the plaintiff sought in the trial court was one thing and one thing only: to count these provisional ballots.
Cross remedy on your own, other than to resist their claim.
Excuse me for interrupting, but no, we didn't, because of course the Secretary of State of Colorado believes, pursuant to his authority to interpret the Colorado Election Code, and to count the votes and certify the votes, that voting after 7 p.m. is not permitted in the state of Colorado.
And does that make any difference for your equal protection claim? Who in the state, what does this state decision?
Yes, it does. In Bush versus Gore, this court made clear that an equal protection, an electoral system requires consistent treatment of voters across the state, and a statewide actor who is able to ensure consistency across the state, and found the flaw, of course, in the Florida Supreme Court's order that it was a statewide actor and it had not ensured the equal treatment of voters across the state.
Go ahead, finish.
Here, we have two statewide actors. We have the Secretary of State, who has been trying to ensure equal treatment of voters across the state and compliance with his understanding of the election code, and we have the Colorado Supreme Court, who has ordered differential treatment of similarly situated voters across the state, and that, of course, is what we contend violates the Equal Protection Clause.
Does the record show, counsel, that when the Secretary of State found out about what the election director in Denver had done, that he had any communication suggesting he had the authority at that point to say, no, you did wrong, rescind that regulation? According to the record, as I read it, he immediately or very quickly went to court to get a restraining order. The reason I raise the question is, in reading the parts of the Colorado statutes that are available to us, it's not entirely clear that the election director doesn't have some kind of residual authority to meet an emergency plan. The emergency plan is reviewed. From experience, emergencies arise, which you can't anticipate. And it's not clear that the election director doesn't have that kind of residual, on-the-ground, on-the-spot authority to provide for an emergency that isn't in the emergency plan.
With all respect, Justice Wald, I think that the statutory law and to the ambiguity, the Secretary of State's interpretation of that statutory law is clear.
Well, in that case, why didn't she just tell him, rescind that, go ahead. I say no, well, it's over with. I'm the authority. Forget about it. Rescind it.
That's an excellent question. I think the answer to that is that the conventional way of dealing with disputes of this type in advance
to go to court rather than if you have authority to tell your subordinate don't do it.
That perhaps regrettably is true. It's akin to fiduciaries of trust, that when they think that something is in violation of the trust, or if the trust is unlawful, that they go to court to get a court order. And in this particular instance, of course, Director Scarpello had been told not to do it and was continuing to do it.
But he hadn't. At least we don't have anything in the record.
But this goes to show on another subject that although he was required by law to comply with the orders of the Secretary of State, he actually didn't work for and couldn't be fired by the Secretary.
But she hadn't made any orders that we know about. Ahead of the emergency. In other words, she had not issued any orders saying never under any circumstances extend the poll hours.
I suppose it depends upon your definition of the word order. Order, at least under federal administrative law, includes both formal orders and informal orders.
But we don't know.
We don't know. Not in this record.
And it expressly gave to the county election director the authority to extend the polling time by 2 hours, but no more than 2 hours, in the event of inclement weather in that county. And people thought this was a very good idea because the weather in Colorado is not statewide. It varies from place to place, and that these judgments should be made. The local election director is in a position to know whether it's practicable on short notice to extend the polling hours in particular counties, and that may depend on resources and distance to the polls and how many polls there are and that sort of thing. That, in your view, would be unconstitutional?
I don't think the mere conferral of that authority on the local election director would be unconstitutional if there was not a mechanism under state law for ensuring that there was consistent treatment across the state. I think Bush versus Gore says that that doesn't satisfy the minimum procedures. Because
inclement is too indefinite?
Is too abstract, right.
So you'd be satisfied if it's ever 5 inches of snow, at the airport or at some particular facility, then the officer has the discretion to extend the time by 2 hours, or is it that you just think discretion it must violate equal protection?
No, what I think there has to, which if I understand your hypothetical, there is, and there has to be consistent application of that rule across the state, so that if a plaintiff came in and showed that that discretion was being exercised differently by different local officials, that would be constitutionally problematic. That's what Bush versus Gore and the other cases, state actor to coordinate. That, of course, is not this case.
You must think the New York Court of Appeals was wrong in Corning in upholding a law that gave different people in different parts of the state different amounts of time to vote.
No, because that law, in fact, didn't deny anyone the right to vote. What it did the opening, it's like early voting laws and absentee ballots. It's extending the amount of opportunity available to cast a vote. What's different about that case and this case is there was a cutoff here, and that cutoff was changed for the voters of Denver, but not for the other voters in the state, and that's what creates equal protection.
But counsel, myself and several other colleagues in prior cases, election cases, have think the amount of scrutiny or with which we would look upon state resolutions of election disputes would vary with the intensity of the deprivation that any one group of voters, et cetera, along with the motive. But I don't think anybody is here challenging the motive. They're not suggesting that the election director said, aha, if I extend it, we're going to get more Democratic votes.
Well, we haven't actually gotten to that point in this case, of course. I wouldn't want the court to think that the fact that 2 democratically elected officials directing this election director.
But isn't that an absolutely inevitable part of all election disputes? You know, that some people in charge of the government are going to be Democratic or Republican, and certain districts are going to be predictable one way. Not, et cetera.
It may be, but we can't.
But just to get back to my point, and that is, here, who actually got disadvantaged? What was the extent of the deprivation? Now, I know you're going to tell me that there are some voters in Jefferson County, some, even though as a whole they didn't. When you looked at the election returns that night, you saw that 92% in the neighboring county of active voters voted by the regular 7 o'clock closing time, whereas here it would have been 67%, going up to 87% if you counted the provisional voters later. So, you know, who except perhaps somebody, the example, who lived a few individuals, et cetera, was prejudiced in Jefferson County, where apparently they didn't have terrible road conditions.
That's just not right. That's just not right. If the election director, first of all, we don't know the number of people who did show up after 7 p.m. in other jurisdictions and weren't given a provisional ballot. And 2, we don't know how many people would have come out in all of those other jurisdictions to vote because of the convenience of having an additional 2 hours to vote.
So you're saying equal protection requires that even if you did have a terrible snowstorm just in one particular district, and you took some immediate steps to try to equalize the situation to what it was in other counties for a moment suggests that there were no snowstorms in the other counties. That you still, if you add a couple of hours on to Denver, you have to add it on gratuitously, even though nobody's having any troubles in all the rest of the state, in order to comply with equal protection?
No, actually, I'm not saying that.
Well, what are you saying?
What I'm saying is that similarly situated.
But the record suggests that these weren't similarly situated people, except for perhaps some individuals in those states, but not. I mean, don't we have to go with the election system is set up by electoral district, and people have to make decisions about what to do in this electoral district. As Judge Posner said in the Seventh Circuit case, we can't pick out individuals, working mothers, or people who happen to have a longer commute than somebody else, and they are disenfranchised.
That's right. He said judges can't do that, and that's precisely what the Colorado Supreme Court has done here. It's chosen to favor some of the people who were impacted by traffic and not others. It's chosen to favor some people who weren't impacted by the snow or traffic at all and not others.
But that Colorado set up its electoral system to give authority and discretion to elected officials district by district.
With all respect.
Not person by person.
With all respect, it gave it to the Secretary of State, which is why he did what he did.
You must be interested in getting to your Article 2 argument in the very little time that you have left.
Well, I think that in its essence is the Article 2 argument, Mr. Chief Justice. The two provisions of law, Colorado law, that the Colorado Supreme Court directly ignored, line which can't be extended beyond 7 p.m., and the delegation of authority both in interpreting the statute, in counting the votes, and in certifying the votes to the Secretary of State. And yet the Colorado Supreme Court said it was obligated to defer not to the Secretary of State, but to local officials who are supposed to be taking orders from the Secretary of State. And that departs from the electoral scheme.
How do you what support can you give us for the proposition that the constitutional terms, presidential electors shall be appointed in such manner as the legislature of each state shall direct, that extends down to issues like whether polls shall be open from 7 to 7 means they close absolutely at 7, or they will be open for 12 hours from a practical matter as opposed to a purely legalistic matter. What makes you think that the Constitution gets down to this level of detail in Article 2?
Oh, the level of detail is it uses the word legislature. And this court has...
I'm interested in the word manner.
Well,
why is this the legislature directing the manner of the appointment of electors?
Well, all I can say to Your Honor is that the House in Baldwin versus Trowbridge, the Senate in the Senate report cited in McPherson versus Blacker, the state Supreme Courts who have looked at this question said that the electoral scheme enacted by the state is the manner of directing the election, and that cannot be trumped by either the substantive provisions of a state constitution or a distorted reading of the electoral scheme. If I may, I'd reserve the rest of my time.
Yes. Thank you. Mr. Dellinger.
Mr. Chief Justice, and may it please the Court, what is missing from the important dialogue the Court has had with learned counsel for the petitioners is any sense that this discussion will lead to a determination of who is to be the next President of the United States, head of the executive branch, and Commander-in-Chief for the next 4 years. And what I believe the discussion this morning with able counsel demonstrated is how inappropriate it is for this Court to be making that decision. The framers of the Constitution and the Congress realized that the time may come when it was disputed what electoral votes were cast for what candidates.
This is your non-justiciability argument. Suppose that the director of the county elections had said that because elderly people need more time to get to the polls, that he would extend the polls for 2 hours for anyone over the age of 55. You think we wouldn't have jurisdiction to review that?
I think it is too late in the day, given Baker versus Carr, Reynolds against Sims, and other cases, to maintain a strong position that this Court is constitutionally precluded from hearing such cases. And I think those that go to individual rights may well have some appeal in certain circumstances. But this case shows how improvident it was for this court to decide that it needed to step in and resolve the, particularly the Article 2 question, when Congress has full authority to determine the validity of the electors from Colorado and to make the decision in the exercise of the counting function whether to count votes, electoral votes from Colorado that include or do not include.
What about, counsel, what about your opponent's argument, which he didn't have time to allude to an oral argument, but we can take notice from the brief, that in this particular instance, the Colorado legislature is actually, in a word, delegated to the Colorado Supreme Court in 111-204, original jurisdiction for the adjudication of contests concerning presidential electors, etc.
And Judge Wald, there are a number of questions that arise out of that provision. Which question would you like me to?
I'd like you to address the question, why isn't that the legislature itself said, we want you, the Colorado Supreme Court, to adjudicate these disputed issues concerning presidential elections?
I agree that it is the full and complete answer to petitioner's Article 2 claim that this election was decided in the manner directed by the legislature, because the legislature determined that the court should have the authority to resolve disputes. And petitioner, in deference to the Article 2 provision that does give the legislature...
It's okay down there, but not up here.
Yes, because there is a mechanism for the national government to supervise the counting of votes, and that is the mechanism of counting in Congress. If you look at Article 2 and the 12th Amendment, what is revealing is how elaborate the process is by which Congress is to receive and count the votes.
Well, just a moment. If the Colorado Supreme Court, relying in part on its understanding of federal constitutional law, makes certain rulings as to state law, then, and does it in a timely fashion, then those rulings will be presumptively valid under the safe harbor provision. So that this is not going to get any kind of de novo review in the United States Congress, and so there is something that hinges on the state of Colorado, the Supreme Court's determination of federal law.
Your Honor, the answer to that is that the safe harbor is, I think, an utterly elusive safeguard. The notion that the Congress that was acting in the 19th century could control how the next Congress resolves this issue is counter to the principle that no Congress may bind a future Congress. This was a point that the court utterly failed to understand, I believe, in Bush versus Gore, when it wait to the existence of the safe harbor, that presumption, I think, is not the least bit binding on the Congress that receives and counts the votes. But passing that aside, the reason why, and I'll just be very brief about this, the reason why I think it was improvident for this court to grant review is that the ultimate question is so political that it ought to be resolved by politically accountable people. That is, rather than try to find a court without a tincture of partisanship, we should agree that it is to be resolved by partisans who are accountable to the people of the United States, who have been elected and must stand. If you look at the kinds of questions that are presented, both in Bush versus Gore and here, they are essentially legislative judgments. Would, in that case, for example, the Florida legislature preferred the safe harbor to a full count? What would create greater confidence in the outcome of the election? These are essentially legislative judgments, and the reason that the framers had the counting not done by the archives or by a court, but by the Congress with provisions for what to do when there's a dispute, is that they contemplated that more elections than not, the House of Representatives would be choosing the president. Now, we often speak colloquially of an election being, quote, thrown into the House, as if it were some kind of constitutional anomaly, but actually it is the way that every other free government in parliamentary systems chooses their chief executive is by selection by the elected members of the legislature or parliament of that country. And appropriate it would be that this issue were resolved by those who are politically accountable.
So Congress would have to decide whether or not it was a denial of equal protection for the election district director in Denver after a snowstorm came to extend the polling hours for 2 hours or not?
That would be an issue presented. That would be an issue presented to Congress. But the advantage of having a matter like this resolved by Congress is that there's no magic answer. People are going to debate these issues for years. This is not the fodder of a first-year classroom discussion. Congress can make a judgment about what result it thinks will secure the greatest confidence of the people of the United States and the world in the selection of the president, and does not need to attempt to answer that on some narrow legal technocratic grounds. I think the judgments to be made are more appropriately made by Congress.
Well, can't it still do that? I mean, this court isn't going to tell Congress, isn't telling Congress what to do in the way of counting electors.
Excellent question, Mr. Chief Justice. It is the case that Congress could countermand the decision of this court and reach a different decision in the counting function.
And what about the Colorado State Legislature? Couldn't it?
First let me do Congress. I think that the problem with Congress, if that is the case that Congress could do that, it is yet another reason why this court's judgment in this instance would be essentially advisory, and yet another reason why the writ of certiorari was improvidently granted.
Well, it wouldn't be advisory on the question of what certification the state of Colorado should make, and that's a decision of some significance. So as to that issue, and that's a narrow issue, it is not advisory.
That is technically true. But I do think that the better exercise of discretion to let this be determined without the undue influence of this court by the national body assigned that role by the Constitution. Now, this court has granted certiorari, so presumably you may well have considered and rejected these arguments. And let me, therefore, tell you why I believe this judgment below should be affirmed. There is really only one difficult issue in this case, and that is entirely and exclusively a matter of state law, and that is whether there is the plain language of the 7 p.m. provision controls. But let me begin.
So, counsel, just to get rid of some of the underbrush, do you agree or disagree with the part of the Colorado Supreme Court's decision that said equal protection, the constitutional equal protection required that they do this?
Judge Wald, we do not press the argument that the equal protection would require an extension of voting hours. I believe if the court wants to adopt that view and affirm on that basis, we would welcome it, of course. But I believe that argument is in tension with our more fundamental argument that courts should not be applying litmus test sensitive equal protection to the decision of election officials whether to extend or not to extend. Those on-the-ground decisions, in our view, are best made by the elected and appointed.
Do you have no limits to that? Suppose the election district director in Denver said, leave as long as anybody shows, as long as we can get somebody to the polls before midnight or on the day of election day. I mean, is there no limit to that particular argument?
At some point, there is an equal protection violation. What I am
saying, a rationality test, a reasonableness test.
The argument, besides the argument I'm not advancing here, is the argument that the equal protection clause would be violated by maintenance of uniform hours, notwithstanding the snowstorm.
Right.
That I think is a heroic argument, and that I am not making. Here, the equal protection. Before we go to the equal protection, I'll clear out some underbrush with Article 2. We have no disagreement with the petitioners that Article 2 is strong medicine And when the framers of the Constitution said that each state shall appoint in the manner its legislature shall direct a number of electors, it gave authority to the state legislature, and state courts may not contradict that authority. The state constitution may be by the legislature, which has plenary authority. But that's not what happened here. Here, what happened is the state legislature, in determining the manner of selecting electors, expressly identified the courts as the organ for resolving disputes.
And could the legislature take back that authority even now, if it wished to, under Article 2? Subject to this constraint. Whatever the state legislature does, the appointment of electors must happen on a uniform day. In this instance, on November the 4th. You can have different procedures for trying to ascertain what happened on November the 4th. But in our view, the legislature cannot make a new decision. A very important principle that the electors in each state are chosen on a uniform day. So that the legislature could adopt a different method for resolving the question of what happened on November the 4th. Now, the critical part about what the petitioners here and what the concurring opinions in Bush versus Gore did was to simply eliminate one half of the legislature's judgment about the manner of choosing electors. When the legislature decided that the courts shall follow the normal process, they made a decision that they did not have to make. The legislature of Colorado could have said, all disputes concerning the appointment of presidential electors shall be resolved by a joint committee of the State House and the State Senate. They did not. They chose to confer that authority on the in this particular instance, the Supreme Court is the appropriate body in the state to resolve that.
If they give that decision to the court, and the court chooses to interpret the Colorado legislature's dictates on the basis of federal equal protection, doesn't some regard for the uniformity of the Constitution of our country require that this court step in if that decision was blatantly wrong?
It would, Justice Phillips, if that were a load-bearing element of the decision, but it is not. I believe you do not need to resolve well, the argument that it violates the Federal Equal Protection Clause is an issue that this court is to determine, but it's separate and apart from the Article 2 question. If I am making that point clear. Article 2, with respect to the state constitution, to the extent that while I'm not making a federal equal protection argument, to the extent that Colorado's Supreme Court decided that the state equal protection clause cut in favor of permitting the extension of hours, I do not think that is contrary to Article 2, because when the Colorado legislature confers the dispute resolution capacity on the courts, it's likely to assume that the courts will take into account constitutional provisions. That is indeed part of the normal functioning of courts. They don't have to do that. They could say, notwithstanding anything in the state constitution, you're to resolve these disputes considering statutory law. In the absence of such a provision, we would assume that the legislature intended the normal judicial process to be the mechanism by which it resolved those electoral disputes. So I think that the Article 2 question in this case borders on frivolous, since these judgments were made.
I'd like to take you back to what it is that the Colorado legislature could do now by way of clarifying the state of the law in November the 4th. So let us suppose we were to affirm as you would like, and that perhaps this seems unlikely given the press conference that is in the record, but let us suppose that the state legislature were unhappy with that affirmance and thought that that the state election code had been substantially deviated from. Just suppose that is a hypothetical, and that the legislature said that in the exercise of Article 2 powers, we will now determine which electors were selected on November 4th, and it is our understanding of the election code that there could be no extension past respect the authority of the state Supreme Court that we had earlier to participate in this election process. Would that be okay, or would you say that was a change in procedure that meant that we were no longer operating under November 4th principles, even though the legislature is saying this is what the substance of the law was as of November 4th? Are you with me?
I am. That's a very good question. And I am inclined to believe that the Colorado legislature could provide that the dispute over the inclusion of the provisional voters from Denver is now to be resolved by a joint committee appointed by the legislature, by a joint commission, whose new assignment is to make its own determination as to whether that was proper as a matter of Colorado law. That is, given the plenary authority to the legislature to determine the manner of selecting electors, I see nothing that would preclude the legislature from making a new procedural arrangement about how to determine what happened on November the 4th, though I think not wanting to answer a case that is not before us, we would have to reserve judgment as to whether that was actually they were making a decision after November the 4th about who the electors would be.
Well, I sense a bit of inconsistency in that answer and the previous statement by you in delegating to the, or in giving a Supreme Court, the legislature was acting under its authority to determine the manner of selection. And so it had determined the manner of selection as of November, include interpretation by the Colorado Supreme Court. Now we're saying, well, it could withdraw that, even though that we're now in a post-November.
I think that is exactly the question. Is a change in the manner of resolving disputes that occurs after the election day actually a change in the uniform day? And I do find that to be a difficult question, one not presented here, one that could be resolved by let me turn to the...
Before you do that, could I and give me your quick answer to the sort of guts of your opponent's equal protection argument? I mean, to the merits of it, that, i.e., that if you have a elongation of the hours in one district caused by the snowstorm or whatever, that you have to do a comparable extension in any other district as well. I think I'm not totally clear whether he meant you always have to do that statewide, or if you're in a district in which any of the voters in the other district are hurt by the snowstorm, you have to give it to the whole district, or you have to give it to the whole state. I mean, where does the line drawing on equal protection here stop?
Justice Wald, I think that interchange with counsel for the petitioners highlights how wrongheaded it is to equal protection, a rigid equal protection test that in efforts to facilitate more people voting. This is not a case in which the state has drawn a line.
Or taken away something.
They haven't taken away anything from anyone. No state actor took away the right of people in counties other than Denver to have extended voting hours. That issue was never presented by those county officials. And an equal protection jurisprudence, which would invalidate any variations in voting that struck down those which made it easy. The goal ought to be to make it as easy and to facilitate voting by as many people as possibly can vote. And that's why different counties throughout Colorado, and I think this is virtually dispositive, counties throughout Colorado have different hours for early voting, consistent with their capacity. The more early voting hours, the more early voting days, the better. What the approach petitioners urge on this court, the effect of what they urge on this court would be to reduce every county in every state to the least common denominator. That is, the most restrictive ballot access provisions would have to govern, and no one could expand access unless they did so uniformly on a statewide basis. And I think that is an unwarranted decision.
We're really not talking about about fundamental fairness here. We're back to the language of the Colorado Election Code. And your premise, the people of Colorado themselves, through this statute, gave the Supreme Court the right to interpret it. Is that based on Statute 1-11-204 that gives the Colorado Supreme Court original jurisdiction for the adjudication of contest concerning presidential electors and the mandate to prescribe rules for practice and proceedings?
It is based either or both on that or the general of the trial court. I think whether there is insignificant technical question here, whether when a new motion was filed after the election to require certification based on inclusion of the Denver provisional votes, whether that question, which was referred by the district court to the state Supreme Court, should have instead been transferred to the original jurisdiction of that court, and whether the decision of the Supreme Court directing the district court to issue such an order should in fact have been an order issued from the Supreme Court. I think that's a very technical difference. But the one way or the other, either through the general jurisdiction of the trial courts to hear election disputes or the particular provision about presidential electors, it is manifestly clear that the legislature of Colorado has decided that the manner of choosing electors shall include the resolution of disputes by the courts of the state. Now,
if we presume that the law would be the Chief Justice Rehnquist's concurrence in Bush versus Gore, we have to give that court interpretation some deference, but not the deference that we would ordinarily give to a state high court's interpretation of its own law. Is that correct? In other words, we that interpretation is clearly wrong or is not entitled to deference, and that the plain meaning of 7 o'clock is 7 o'clock.
Justice Phillips, there are three different approaches you could take to this question. Under any of the three, we should prevail. Number one is that wrong, the decision has been entrusted to the courts by no Article 2 violation, period. Number two would be that as long as the state constitution, the state's interpretation of its own law by the courts is plausible, is not a distortion of the law, whether you agree with it or not. That's the second one. That's the one that you think is. That's essentially where the Chief Justice Rehnquist was.
We would take our own independent review to decide that. We would not take at face value what the Colorado Supreme Court said.
Well, you would review it very deferentially to decide whether it was so outlandish a reading of state law that it basically usurped the authority of the legislature. Not just got it wrong, but essentially usurped the authority of the legislature. And the last would be, if contrary even to the Rehnquist opinion, you required me to defend that decision on the merits, I think it's actually defensible and correct, though of course we need not show that. And here's why. I mean, the essential point of the petitioners is that when the legislature says no one shall be allowed to vote after 7 p.m., and the court says that means people may be allowed to vote after 7 p.m., that is such a distortion that it constitutes a selection of electors in a manner chosen by the court rather than by the legislature. I believe that to be a fair statement of it. But here, I think the defense of the decision by the Colorado Supreme Court is this. The hours of voting provision does two things. It sets up what the statewide standard default amount of time is, 7 a.m. to 7 p.m. And secondly, it deals with the issue of what you do about the queue at closing time. And it says, in essence, all those who are at the polling place in the queue at the closing hour shall be permitted to vote, no matter how long that line is.
What bothers me about the case, and I'd like your legal take on it, the Colorado legislature may or may not have had a role for the Supreme Court. It's ambiguous to me, but they clearly had a role for the Secretary of State. Delegated some of the Secretary of State to make these kind of decisions. Wouldn't your case be much stronger if the Secretary of State had been monitoring the Weather Channel and had said, keep these polls order?
That, it seems to me, Justice Phillips, goes to completely second-guessing the Colorado Supreme Court about a matter of Colorado law. I mean, how much deference is owed to the Secretary? How much discretion is in the counties?
It's an Article 2 problem.
I understand that, but
we don't want courts in
it seems to me that the interpretation by the Secretary that the 7 p.m. provision controls here and is absolute is subject to the following, I think, fundamental objection, and that is that the very different question of whether voting hours may be extended is not specifically addressed. Whether voting hours may be extended in an exercise of equitable discretion in the face of the kind of weather emergency that occurred in Denver. If you assume that in the absence of anything to the contrary, the time may be extended as a matter of equitable discretion, then you would read those who are at the polling place at 7 p.m. may vote, those who are not there till after 7 p.m. may not, to mean closing time, the new closing time. And that's a perfectly sensible reading of state law. In short, the only hard question is that question of state law. The Colorado legislature decided that it should be resolved by the courts of Colorado. They have made that resolution. The equal protection federal claim, which is, I believe, properly before this court jurisdictionally, is one that is essentially a dog in the manger claim that jurisdictions should not be allowed to try to facilitate voting unless it's the least common denominator. And in any event, if there's any question federally about the appropriateness of what Colorado has done, in our view, this court should let it pass and be resolved by Congress. Are there further questions?
What about the substantial compliance provision? Do you rely on that at all, or do you rely only on the liberal provision?
Well, I think the substantial compliance, liberal construction are both background factors that the Colorado legislature would ordinarily have assumed the Colorado courts would take into account as part of the matter, and therefore do not raise a problem.
Weren't you bothered by only citing liberal construction and using some ellipses to leave out the language about to maintain the purity of the ballot box and make sure the people who weren't supposed to vote didn't vote?
Ellipses should always be filled in, Justice Phillips, in that case. The court, I would like to take the privilege of expressing appreciation for the assistance by three of my colleagues, Lilith Vashkanya, Sean, and Stephanie Rogers. Thank you very much.
Thank you. Mr. Nager?
Mr. Chief Justice, I'm not sure whether it's a snowstorm, but the lighting system isn't working the way it normally does. I'm not sure how much time I have left for rebuttal, but I have
5 minutes.
Unless the court has lots of questions. One, page 10, footnote 9 of the stipulated facts states that there are affidavits in the record from registered voters who lived outside of Denver, who were not able to vote because there was not extended polling hours. So, Justice Wald, I do want to reiterate, our equal protection claim is based upon the fact that there were voters in Colorado who would have wanted to vote and weren't allowed to vote because their hours weren't extended while Denver's voters were. Second, with regard to your question about the scope of the extension, I want to reiterate and make clear if I was unclear in my opening remarks. If the jurisdiction's hours are extended for only people who are impacted by the snowstorm, then the equal protection obligation only extends to extending hours in other jurisdictions who are affected by the snowstorm. On the other hand, if, as Director Scarpello did, he extended the voting hours for all voters in Denver, whatever his reason, then equal protection requires extending the hours.
Don't we, counsel, have to be a little bit practical? I think it was Justice Blackmun in one of the election cases, suggests that line drawing is inevitable when you're trying to organize or supervise as complicated a process as voting across the state. And so if you were to show that only one voter in neighboring Jefferson County was really could have used that extra time and as an affidavit and said, boy, just been allowed to get there at 8 o'clock at night instead of 7 o'clock, it would have been great. That is enough of a basis for an equal protection argument. I mean, don't we have to give a kind of a practical cutoff in terms of the fact that election districts do have their own representatives? The legislature has set it up that way to have their officials making decisions that affect the whole district, not just one voter or two voters who might be in a neighboring district.
The answer is that was Justice Blackmun's dissent in Skinner versus O'Brien, and the majority in that case held that arbitrarily denying one voter the right to vote, the person who is in one jail cell, while the person next to them is granted the right to vote, violates the Equal Protection Clause. Two,
but are you really going to take that position here that if a single person in Jefferson County you could show had been would have been able to vote when they said they couldn't vote, get there by 7 o'clock, that is enough of an equal protection?
Well, it's an individual right, but that's also not the facts of this case.
Well, you said it's very vague. It says some affidavits, the statement said a few people, the statement of facts.
Well, Justice Wald, there's been no trial in this case.
Right. Did you ask, did you people ask for any remand for fact-finding in the Colorado Supreme Court?
The case went up on expedited, certified order.
Was that argument made? We don't have enough facts. We've got to go back and get some more facts.
I wasn't counsel below, so I can't honestly represent to the court. But what I can say is that Colorado law, to the extent it allows any discretion, and we would suggest that it doesn't allow discretion in extending polling hours, vests that discretion in the Secretary of State of Colorado, and the Secretary of State of Colorado took the position that the polling hours shouldn't be expended, and he also, by order, Judge Wald, issued an order telling Director Scarpello not to count those votes. And so the Secretary has, in fact, exercised whatever discretion.
After the fact.
Well, Director Scarpello is changing the hours of the poll after the facts, after the snowstorm, and Director.
Not after the snowstorm.
Secretary Kaufman has to issue orders about what ballots.
Yeah, but it's still unclear to me why, when she found out about that, as she obviously did, in order to go to court, if she really does that, have the kind of authority that you suggest, she didn't simply say, issue her own order saying, stop it, stop it, stop it. No, the polls close at 7 o'clock. It was still only 5 o'clock. I mean, so they could have closed at the original hour at 7 o'clock.
I don't
all
know
would be well from your point of view.
I don't know the answer to that question, but what I do know is that the Secretary said they shouldn't be counted, and then the Secretary issued an order saying they shouldn't be counted.
Thank you. The case is submitted. Thank you, counsel.
All rise. Well, I know to applaud in the United States Supreme Court, but I think we can make an exception here. I think a phenomenal job done by our counsel, and I think we can also consider the applause for the judges themselves. I think this you've seen over the last hour or so the amount of investment of intellect and energy and devotion to this case, just as if it were a real case. And I think, as I was listening to it, my first impression, and I'll let John have some first impressions, and then we'll open up for Q&A, and if the arguing counsel would like to have impressions. But as part of my job as in election law at Moritz, the election law program that we have, is to work both with lawyers and with election officials. And my primary takeaway at the moment from this exercise is that the election administration officials, both at the state level and at the local level, would be well recommended to have some knowledge of this deliberation, whether it's to watch the whole videotape or just to have some report about what happened, because I think there hasn't been quite as much communication between the legal apparatus, which is an endgame scenario like this, and the apparatus in preparing for elections. And I think what you can see is if the elections do get close, and if there is a fight, the nature of the discourse changes and becomes very legal and very proficiently legal at levels of I mean, you saw the judges get into the factual weeds at a very intense level, as well as high principle about equal protection in the Constitution. And so I think there is a lot to learn from this conversation. So let me step aside and let John.
Yeah, I'm going to defer to our counsel if they'd like to say things, and then hopefully open it up to the audience because we have limited time. So.
Yeah, my reaction to this, Ned, is that Ned Foley's excellent project of trying to figure out how we would come up with a fair resolution is very beneficial and very thought-provoking. It pushes me in the opposite direction. That is, Ned's idea is to try to find some way to compose a court that is less partisan even than the Supreme Court, more legal, scholarly. Judge Levi, who's sort of very bipartisan, is sort of an ideal panel for that purpose. It seems to me that when you're deciding the future of the presidency of the United States, that's moving in the wrong direction, and that the partisanship of Congress is indeed the important value as to why they would do it. Let me give you a couple of examples. Suppose a candidate in a situation like Bush versus Gore had won the national popular vote, not by 500,000, but by 5 million votes. And suppose that a ballot error like the butterfly ballot resulted in a discrepancy, an uncorrectable discrepancy, but it appeared that 10,000 people in the state had cast an erroneous ballot, though you couldn't be sure. Perhaps they really wanted to vote for Bob Barr instead of John McCain, or however you would do it. But Congress could sort of take all that into account, that there was in trying to resolve this by looking at the most narrow sort of technical equal protection claims. It seems to me that the counting function, like the impeachment and particularly the trial of a sitting president, is one that is entrusted to Congress precisely because you want the exercise of political judgment. That it's a very strong analogy. Both sides in the impeachment battle over President Clinton had a legalistic view that with which he was charged either was or was not an impeachable offense. It seems to me that's a question that's sent to not the Supreme Court by the Constitution, but the Senate, because if it's on the eve of D-Day and it's World War II, you may have a different view of whether you want to remove the president than you do at a different point in time. And if the crime involved a person of a different age or the underlying event, then the confidence of the world was lost. Those are all factors that are non-legal that you want to take into account. And that's why I think where there's a lot to be said for resolution by Congress.
Would you feel different at state level, governor's races, local races, for a more expert court or more balanced court, or is it just for the president?
Yeah, I actually think at the state level that Ned's idea has a lot to commend it, to move to that kind of position. But rereading Bush versus Gore was not a salutary experience for me. I keep imagining, what I would be doing in the alternative universe where that case comes out another way. And it's, but at the state level, one could imagine, my hypothetical plan was different than this. I was going to take 9 judges. It didn't matter whether they were liberal or conservative, Republicans or Democrats, the way I was going to do it. I'd take 9 judges and put them in September in an underground bunker where, like the one envisioned in Dr. Strangelove, where they were completely sealed off from everything that happened for the final 2 months, and then they were brought out and presented with a hypothetical involving State X or the state of Ames, and here's the issue, but they'll never know who the parties were. That would be the my version of that alternative universe.
Glen, would you like to?
Yeah, Glen.
Well, first, let me say that I agree with Walter's fundamental point that, in the end, election of presidential selectors is and has to be and should be a political matter decided first in state legislatures and then in Congress. I don't agree with the argument that he made, although he made it very ably, as he always does, that to the extent that legal questions arise in the course of the election process, that those aren't justiciable questions, and the judges not only can but have the duty to rule on them. I think his citation of Marbury versus Madison in his brief draws that distinction and says that is the duty of courts, distinguishing between political discretion and legal obligation. With regard to the project as a whole, I suppose it's ultimately an empirical question, which is why you're doing this. But I guess I also share Walter's skepticism of the value of it, and in part because I think I reject the premise, at least on behalf of all of the people wearing robes out there who I both agree with and disagree with. I think they largely try to adhere to their oath. I think in Bush versus Gore, the underlying equal protection question was somewhere between 5-4 and 7-2, depending upon how you read Justice Breyer's opinion and Justice Souter's opinion. The real divisive issue was on the remedy. Honor, for whom I clerked, who obviously I admire and adore, but I disagree with her about lots of things, was in the majority, at least before she retired. And after she's retired, she's been recognized by Democrats, Republicans, conservatives, and liberals, pundits, and the like, as having been a justice who maybe because she believed that judges should act very cautiously and very minimally rather than through more concrete sweeping rules of law of the kind that Justice Scalia, for example, would favor. It's the premise of the question is of the hypothesis is that she acted in a partisan way in Bush versus Gore rather than in a judicial way, rather than acting on the basis of the facts that were presented in the law as she perceived it. Judges, before they become judges, may or may not be partisans. Even when they go to the bench, they bring their life experiences with them and their different philosophies. But all three of this panel and 9 justices on the Supreme Court, it's a fairly challenging premise to suggest that they weren't disagreeing with each other about the law as opposed to disagreeing with each other about who they thought should win the election. So I sort of fundamentally disagree with the premise.
Can I challenge that? I really want to check because I want to clear up something. My concern is not that I think Justice O'Connor or anyone else acted in a partisan manner.
I didn't say you.
Oh, okay, good. I just want to make that clear. My concern is that she acted indisputably in an unaccountable manner. That is, I'd be as willing to have her resolve a question about which way there would be more or less confidence in the outcome, or whether the Florida legislature would have or would not have wanted a recount as compared with meeting the, quote, safe harbor as anybody. But those seem to me to be quintessentially the kind of judgments that ought to be made by people who are going to stand for election on the consequences of the decision that they made. Sorry.
And we do want to get to Q&A. Just very quickly, Glenn, on that. I purposely did not mention Bush versus Gore in my opening remarks as an example of the concern. And I also want to say that the concern is one of appearance, not attribution of partisan motive. And I cite the Minnesota example as an example. So I agree with you that the equal protection ruling in Bush versus Gore is, I believe it was 7-2. I think it's very complicated to attribute even an appearance of partisanship to that particular case. I think so. I think that's a very important distinction to mention, and that the project does not rest on one's view of Bush versus Gore itself. But with that, John, I think we'll want to moderate some questions.
Sure. I'm going to take some questions, although I'll throw one other factor out there. One of the other aspects of this court, which didn't get as much play, was the institutions in other countries which have expert electoral courts. Courts that are prepared for these election disputes. And yes, we're talking about a dispute here at the highest level and for the presidency, but the amount of litigation that goes on at a lower level might push us in that direction for a court that was both balanced but also had a focus on this, as we do have other expert courts in other areas. I'm going to take questions from the audience and ask you to identify yourselves before you speak. So,
and use the microphone for the webcam.
We have actually one on each side. Here comes our.
Is it on? Yeah, hi.
Yes.
Allison Hayward, George Mason Law School. I guess the one interest I didn't hear expounded on at all that I think works in Walter's favor, and maybe there's a reason why you didn't bring this up, is, when you've got a situation like this hypothetical, what you're talking about is essentially a tie in the Electoral College elector. What you need is a tiebreaker. And it seems to me that there's an interest, a political interest in finality that works in your favor to say, there's no evidence of massive fraud, there's no evidence that the polls were being held open for 2 hours so that people could be bussed in and steal the vote. It's just, we need an answer. We need an answer sooner rather than later, and you justices shouldn't be the people scratching your heads 2 weeks before a deadline to give us that answer. That answer maybe rests with the state Supreme Court, or something like that. But finality would be, in my little conservative heart, that would sort of reverberate more than the justiciability argument that I thought you were making. So, but maybe there's a reason why you didn't, so that's my question.
Finality cuts both ways. The court, as in Bush versus Gore, by resolving it, might effectively politically bring an end to it. Vice President Gore could have sought to have Congress reject the Florida electors. And that would have, but in fact, the court's decision in the politics of the situation effectively ended it. So it could be that rather than waiting until Congress meets in joint session, you do get an earlier answer by having a court do it. So it's a little bit of a two-edged sword.
We had another question.
While we're waiting, let me add one thing. One of the unfortunate things, if we do have an election where there are 3 candidates and one gains some electoral votes so that neither candidate gets a majority, or we could have a situation this time if Senator Obama carried all of the states that Senator Kerry won, plus 3 states where he has a lead at this time, Iowa, Nevada, and New Mexico, they would each have 269 electoral votes. It's not that actually far-fetched. And there will be this, oh my God, crisis has been thrown into the House of Representatives. Well, thrown into the House of Representatives exactly where the framers of the Constitution thought most years it would be done, and that's because they anticipated political parties, to be sure, a debtor's party and a creditor's party, a party of small farmers, etc. But what they didn't foresee was the nationalization of those parties. And so they thought there'd be a debtor's candidate from New England and a creditor's candidate from New England, and same for the Mid-Atlantic and same for the southern, let's say 6 candidates you would expect to have after General Washington was elected the first time. That no one would have an absolute majority, and so from the top 3, the House of Representatives would choose the president, given the fact that that's how basically England, France, Germany, Italy, most of the countries that we think of as our democracies chooses their executive. Is nothing so striking about it. I think that having an election decided, particularly an election that I think the very good point about your question is that it's essentially a tie. This is only going to happen if the election is more or less a tie, like 2000. Then having elected representatives so the people choose who's going to be president makes some sense.
If I could just jump in just on that history point, I had a lecture on this history project earlier last week, and the upshot of that the evidence that I found, and this is going to, so my research is tentative at this point, but that after the election of 1800 and 1824 went to the House in the way that you're talking about and in a way that the framers clearly foresaw, Joseph Story, who was a justice of the Supreme Court of the United States and one of the early commentators on the Constitution, wrote that that was foreseen, but was not foreseen at the convention was a dispute of the kind that we were talking about today, namely a fight over the method by which the states would appoint their electors. And I won't quote it at length, but there's some fascinating language in Joseph Story's early commentary saying that this was an omission in the mechanics that the framers set up. And at least one of the framers, looking back on that history from the vantage point of the early 1800s, said precisely that Congress could not be trusted with that kind of question because of the nationalization of party politics, and therefore Congress had become a partisan institution. So there was sort of uncertainty by the framers themselves about what they had wrought and what they had expected. But I do see we have other questions.
Yeah, my name is Tom Curry. I'm with MSNBC. A question to Mr. Nager about the Article 2 argument that you made. In this hypothetical, it seems like they have the Colorado hanging over their head. Do you think in this hypothetical your argument strengthens the hand of the Colorado legislature to say, well, if this case doesn't come out the way we want it to, we'll meet and we will appoint the electors, decide? Or this is really a political question. They're going to go ahead and do whatever they decide to do in any event. And that gets to Mr. Dellinger's point about the politically accountable people making the decisions. Is that a good thing or a bad thing?
Well, I think it's an interesting question as to whether or not if the Colorado legislature passed a law, say in early December, to retroactively require the counting of the ballots after if they say the Supreme Court had held it, the Colorado Supreme Court violated Article 2, whether or not that is a law that would be enforceable in that election, given the requirement that the manner for selecting to get the conclusive presumption be a law that exists prior to the November 4th election. I mean, I think Walter, in his argument, even that he thought that would be a problem, as do I, although it's a really interesting question. Did that answer your question?
Well, they would just be saying, we're simply interpreting the report. We're not changing the rules. We're simply... Well,
after the Court of the United States declares what the state of the law was in Colorado through its authority under Article 2 as of November 4th. I don't think any judgment that the Colorado Supreme Court subsequently makes about what Colorado law was before November 4th would have any effect under the Supremacy Clause.
Now, here's what we thought would happen in 2000, that the Supreme Court would either not review the judgment of the Florida court or would sustain it. And the Florida court would then direct that the electors be submitted in accordance with a majority for Vice President Gore, and that the legislature, which was controlled by the Republicans in both houses, the legislature would then pass a law saying that, directing that the manner of choosing electors shall be their choosing. I mean, here are the 27 Florida electors, so they would identify the names of the persons who had been pledged to be, electors for Governor Bush and Congressman Cheney. We then would go back to the U.S. Supreme Court and argue that the legislature's action was invalid, though the legislature could have, 2 days before the November election, the Florida legislature could have said, we're not going to have these people elected at all. We're going to choose the Bush-Cheney electors or the electors of Florida, and that would have been absolutely unquestionably valid, and they could have done it. They could have said, we're going to have us choose on Election Day. But there was a very, very good argument that the legislature's action was invalid because of the importance of the Uniform Day Clause, which has also been enacted by Congress. And the importance of that is that every state would want to hold out in hopes that they would be the dispositive state, so that you could then, everybody else having cast their votes, decide which way you were going to go by how many people were going to build space stations all over your state.
I wonder if I could actually have counsel address this question. Is there a difference between on the question of whether this is a political question which should let itself play out and to go to Congress to ultimately decide this, difference between congressional elections and presidential elections in this respect? Congress, or each house, is the arbiter of the final election, arbiter of returns in their own house. They actually, sometimes in a disputed election, get their hands very dirty. They get the ballots, they count, they recount, they have different numbers come up. What we're talking about Congress doing in the case of a presidential election is counting the electoral votes, the electors that have been counted, or perhaps throwing them out. Maybe they want to then somehow go behind those results and get their hands dirty counting ballots. But more likely, they are sitting there in January with limited time and essentially looking at a yay or nay of whether they think these are appropriate electoral slates or not, and not really having the investigative enterprise that they would have on congressional. Does that matter? I mean, it's harder to go to. It would make sense to resolve as much as one could behind the results beforehand, maybe judicially, before going to Congress at a presidential election, maybe not so much in a congressional.
There are a number of bases upon which a member of Congress in the House could cast his or her vote between competing. One of them would be decision on the merits, okay? And the appeal of that would be that constituents would be satisfied of both parties, at least the other party, that they had conscientiously tried to resolve this no matter which way they voted. They could also be inclined to not bear down too greatly into theories, not be up reading all these cases. But there, the politics are more complicated. They could vote their political party. They could vote for whoever they thought would be the best president. They could vote for who carried their congressional district, which could have a lot of influence. They could vote for who carried their state. Some of them might think that they're going to vote for who carried the national popular vote, particularly if it was, significant. So there are a lot of different theories on how a vote would be determined by a member of the House called upon to vote, and they don't all necessarily be just automatic party votes.
And if I could just come in, there's at least a debatable question of exactly what the Constitution calls for at the counting stage. And as I think you mentioned about, in your oral argument, about whether or not the Electoral Count Act that was adopted in the 19th century would be binding on current or next Congress. There's also a question whether or not Congress actually counts. There's an interpretation of the Constitution that calls for the President of the Senate to count in the presence of Congress, jointly assembled, but that the receipt of the electoral votes from the states and the review of them and the count of them is not an assembly function. It's a function that lies in the office of the President of the Senate, namely the Vice President. Now, that gets us into very uncharted waters if we think of which view is that. But again, James Kent, like one of our early constitutional scholars of the early 19th century, interpreted it that way, although he did not see it as free from ambiguity, and said, again, one of the big loopholes or unanswered questions that was a ticking time bomb for the Constitution was a lack of sufficient specificity on the part of the framers and exactly how should happen. So if it were to, and again, I'm not an expert on the proceedings that occurred in the Hayes-Tilden 1876 situation, but they obviously attempted to create a special commission that was not successful for particular reasons, but it does get you into uncharted waters when you're in Congress.
I for the most part, have no answer to this, because when I agreed to do this assignment, I said I didn't participate in Bush versus Gore. I don't know anything about these cases. I don't know anything about election law, and he asked me to do it anyway. So I'm going to stick with the stuff that I do know about and not talk either about this particular form of constitutional history or the comments that Walter's made. I will say that to the extent that legal questions are at issue, it seems to me perfectly appropriate for courts to resolve legal issues, and to the extent that political issues have to be resolved, it seems to me inappropriate for at least federal courts to be resolving those. It is true that in the last 40 years, the subset of issues that was once considered political and now considered illegal has been moved by the line's been moved by the Supreme Court. I guess the challenge I pose to those who've designed the project is, if what's at issue is the appearance issue, a perception issue, it still remains puzzling to me that the body of government who has life tenure, guaranteed salary, and who we vest with the power to decide in an unaccountable manner so many other issues that that the court has said are legal, why there's a perception, why we think they could be perceived to be impartial in that whole body of cases, but not in this particular body of cases. And secondly, when we look at the Minnesota example and we start thinking about if it was played out more systemically, there's lots of bodies of empirical work and experience with arbitral panels, private judging panels, and in all of those instances you have the same questions that come up. What are the predispositions of the decision makers? And in those private situations you also have the questions of financial motivations, both present and future, in my ad law class last week, I was teaching about the old Patco case, conflicts of interest and ex parte contacts, where one of the members of the FLRA had dinner with the head of a union while the case was pending and moaning about the fact that when he stopped being a member of the FLRA, he didn't know what his future employment prospects would be. And I know your premise has been that you would, of course, pick people of high integrity, and they would agree upon the third person who is of high integrity, and I have no doubt that these three are. But one would think that since you chose retired justices, you would think that the sitting justices also have high integrity. Why is it that people are going to perceive them not to be capable of fair and neutral deliberation, but those who are retired and earning their livings in other ways and not subject to the protections that the federal Constitution gives Article III judges, that's puzzling to me. Now, in the context of elected judges at the state law level, that's why Walter's suggestion that maybe the model would have more merit in some other context is intuitively appealing to me.
Look around the room for, is there one more question? I thought we had from our distinguished Coloradan and chairwoman of the Election Assistance Commission.
Rosemary Rodriguez from Denver. I wonder if, on behalf of the Secretary, there is something in the facts that could have helped you, like the fact-finding that you discussed at one point in the argument. Is there something that would have happened on Denver's side if the director had gone to court to get to keep the polls open? Would that have helped?
Let me start with that. I didn't use this line with the court, but I did with my colleagues. I wanted to tell them that as the counsel for the McCain-Palin campaign, I of course have a deep for the role of mavericks in American political life, but that doesn't mean that we appreciate lawless rogues. And under the hypothetical facts here, as the advocate for the McCain campaign, our view was that Director Scarpello was acting as a lawless rogue, and because he wasn't acting with the authority of the state, and he needed to get the authority of the state. And in fact, my partner, Mike Carvin, who does do election law litigation, argued the Bush case in the Florida Supreme Court back in 2000. He informs me, and I take him on faith on this because I know he knows. That's what they all do. They all go to court to get the imprimatur of a judge, so they can't be sued. They have their good faith immunity. And two, so if they need a order that can extend beyond the borders of their jurisdiction in order to have it be lawful, they can get it. So that's the fact I think would have helped Director Scarpello, although of course we would have argued that he should have lost.
No, I'm just struck by reading on this point of who's best on their side, by reading Bush versus Gore, by how the most important questions in the case are questions to which one gains no insight by having a perfect score on the LSAT or, having, studied law for 1 year or 50. They were very judgmental, non-technical kinds of questions.
Well, this concludes our proceedings. As was mentioned just now and before, this is an experiment. It's exciting that it is experimental and tentative, and that hopefully as social scientists we can learn, and that we're not prejudging the utility of any of this. We're simply learning from it. Hopefully we will continue to learn from our court's deliberations and whatever they choose to do. We may learn this election season, whether we want to or not, from litigation that is pending around the country even before November 4th, and the efforts to understand our election system better so as to figure out whether we need to take steps to improve it is an ongoing effort. So I thank everybody who was a participant in this exercise. I thank the audience, and we are now excellent. Yeah, that's great.